So, good morning, everyone. How are you all? Doing well, I guess. So, today's case that we have to discuss is Internet and Mobile Association of India versus Reserve Bank of India. Okay. The court is Supreme Court of India. The case hails from the year 2020. It's a recent case. Who was on the bench? Justice Rohinton Fali Nariman, Justice S. Ravindra Bhatt, and Justice V. Rama Subramaniam. Date of the judgment is 4th March 2020. Okay. Now, what are the facts of the case? Now, before I begin reading the facts of the case, I want to put up a question. How many of you are aware of the virtual currencies and what are they? Can you people give me a little idea of what is virtual currency and how it is regulated? What is its current status? Right? What is its current status? I hope I am audible and visible to you. Anyone out there? Good morning, Taran. What happened? Have you people just woke up from your beds or still feeling sleepy? What happened today? I used to receive the good morning greetings before even I go live. And today what is happening? Okay. Taran, Zinnia, Soumya are awake and they are attending the class. Okay, now tell me, do you have any idea about the virtual currencies or the cryptocurrencies? Or how they are regulated? What are they? What is their present status? And any one of you, is any one of you having bitcoins or not? Exactly. Mohammad Riaz has very rightly commented that there is no regulation in place right now to regulate current cryptocurrency in India, but it is being taxed. Mehul has just woke up from his bed, and it's really difficult to read and learn about cryptocurrencies after waking up from the bed. Mehul, you are doing a great job, I must say. So Taran is commenting the current status or is that it enjoys pan India, is that it falls outside the ambit of any regulation. Exactly. Right now, Mohammad Riaz and Taran have rightly commented that the regulation, there is no regulation right now with regard to cryptocurrencies and virtual currencies. Several companies have come in India and people have invested money in various schemes of such companies, and afterwards these most of these companies, they came out to be, or they were discovered to be fraud. They fled away while siphoning off money, lots and lots of money from the public. So Sonakshi is not having the bitcoins. Okay, Suruchi is having bitcoins, perhaps cryptocurrency. uh, Salvador was the first country to introduce a legal tender, but the same was later on revoked. Taran, yes, that's right. That's right, Taran. The several countries have made an initiative in recognizing cryptocurrency and virtual currencies, But since there is right now there is no regulation of the virtual currencies, where they come from, who is the owner, how they are regulated, what is their present legal status, and in the recent budget they have been, put under the category of the taxed, of the taxed subjects, like the subjects which are taxed. Now the question is that if you own a cryptocurrency and suddenly what happens, that since you do not know from where it is regulated, since the owner or the company which is secretly or tacitly or surreptitiously regulating cryptocurrency dupes you, what will you do? What will you do if you are duped? For example, if you own certain bitcoins today, and the value rises to unimaginable numbers in the next few months, you can earn a lot of money. But what in a case if the vice versa happens? If the value falls down and suddenly a news comes that the cryptocurrencies is no more with us now. So what will the people do in that case who have invested lots and lots of money in cryptocurrencies? Because that's the example that I was telling you, was that there were several companies who came to India who asked public to invest money in various schemes, in under the guise of various schemes, and like Ram Survey, like Pan Asia. So these were the companies, like people started investing. They also started getting huge amounts of return on their investments. But this happened in the early stages of the company, and later on, after a considerable period of time, after a month or 2 or 3, these companies fled away with the money of the public. So people were duped, they were defrauded. So the question is, what happens? Like, there's no regulation right now. So Internet and Mobile Association of India versus Reserve Bank of India. Now, since here we are talking about currency, the basic question of law that arises here is whether the Reserve Bank of India, that is the apex and the sole institution in the country to regulate currency, has the jurisdiction to regulate cryptocurrency as well, or virtual currency as well. That is the question of law. Okay, since we do not have any regulation at the international level of the cryptocurrencies, can we give this regulation at the domestic level to our Reserve Bank of India, which is the sole institution to regulate currency? That is the question. If RBI is issuing directives to regulate cryptocurrency, if RBI is issuing directives to regulate the and administer the flow of cryptocurrency in India or virtual currency in India, will those directives be good in the light of law? That is the question of law. So Internet and Mobile Association of India versus Reserve Bank of India, they are the petitioners. Internet and Mobile Association of India is the petitioner in this case, and RBI is the respondent in this case, because the Reserve Bank of India issued a circular on April 6, 2018 prohibiting banks and other entities from trading in virtual currencies. Okay, now the RBI issued a circular prohibiting banks and other entities from trading in virtual currencies, that the banks, like for example, if I'm investing in bitcoins or in cryptocurrency, but I am doing it through bank. So can banks, like bank recognizes gold, banks recognizes a list of assets in which you can invest through banks. But if banks are also recognizing cryptocurrencies or virtual currencies as an asset, then this investment can happen. But RBI issued a circular on April 6, 2018, which prohibited banks and other entities from trading in virtual currencies. That means it was not recognized by the RBI. The banks were also prohibited from providing services to the organization or any individual dealing with or settling virtual currency, according to the circular. This circular was published with the belief that virtual currency trade is vulnerable to hacking, which could lead to terrorist acts, money laundering, and other problems. So basically what happened, that the banks were prohibited from providing services to the organization or any individual dealing with or settling virtual currency. Like any person, any customer of any bank which is regulating or dealing in virtual currency, who is dealing in virtual currency or settling anything in virtual currency, the banks cannot in such cases be involved. This was the directive issued through a circular of the RBI. Okay. This circular was published with the belief that virtual currency trade is vulnerable to hacking, which could lead to terrorist acts, money laundering, and other problems. Have you heard of Hawala transactions? Anybody? Have you heard of Hawala transactions? Have you heard of Hawala transactions? Okay, Taran says yes. What are Hawala transactions? Please tell me. Taran, Gauthaman, Riaz knows what are Hawala transactions. Sonakshi also knows. Please tell me. Come on fast. Hawala transactions are those transactions which are, related to the funding of terrorist acts or terrorist organizations. Okay, those are Hawala transactions. In case the funding is happening in normal currencies, then it can be very easily caught or apprehended. Okay. This circular was published with the belief that virtual currency trade is vulnerable to hacking, which could lead to terrorist acts, money laundering, and other problems. Okay, terrorist acts. अगर virtual currency होगी, because there is no regulation right now in the world, there is no regulation of the virtual currency trade in the world right now. So this virtual currency is vulnerable to hacking, and this could lead to terrorist acts, money laundering, and other problems. People are like investing in the virtual currency like anything. So there is a terrorist act, there is a money laundering which can happen very easily, which can take place very easily, and if the banks are involved, this will create a very big problem for the economy of the country. And okay, so Disha is money transfer without money movement. Gauthaman, it's some illegal transactions in foreign currency. Okay, Taran, money is channelized through illegal means. Mehul, Hawala is an informal method of transferring money without any physical money actually moving. It is described as a money transfer without money movement. Another definition is simply trust. Basically, the core of the Hawala transaction is that the transactions which fund the terrorist acts, through illegal means, that is the core of the Hawala transaction. You have to understand this. Okay. So RBI issued a directive which prohibited banks in dealing with virtual currency because such currency is vulnerable to hacking, which could lead to terrorist acts, money laundering, and other problems. The RBI has instructed the bank to refrain from providing the following services: clearing, lending against virtual currencies, account maintenance, registration, trading, settling, accepting virtual currency as collateral, opening exchange accounts, and the sale, purchase, or transfer of such virtual currencies. The Internet and Mobile Association of India filed a case with the Supreme Court challenging the circular. Now, what did the Internet and Mobile Association of India did? Internet and Mobile Association of India filed a case with the Supreme Court challenging the circular of the RBI which prohibited banks in dealing in virtual currency. On the basis of proportionality, the court authorized the same. Earlier in 2013, merchants and holders of the virtue money were advised to be wary of the security and legal risks linked with it. Okay, issues. Whether the RBI lacks jurisdiction to disallow the trade of virtual currency and it based such ban imposed on the misunderstanding. Whether the RBI lacks jurisdiction to disallow the trade of virtual currency and it based such ban imposed on the misunderstanding. Issue was, see, this is the question of law which I highlighted and hinted in the very beginning of the lecture, that does RBI has the jurisdiction to disallow the trade or allow the trade or do anything with the virtual currency? Because there is a misunderstanding with regard to virtual currency, that it is not regulated, who is the owner of the virtual currency, and it is vulnerable to hacking and money laundering. These are all assumptions of the RBI. These are all misunderstandings and myths which have not yet been busted by any international organization. And based on these assumptions, these misunderstandings, these myths about the virtual currency, the RBI has straight away disallowed and prohibited the banks to engage in any transaction, from engaging in any transaction dealing in virtual currency. And also, the question arises if the RBI has the jurisdiction to do so or not, right? So the laws applied, like in order to find out whether the RBI can issue such circular and can disallow the trade of virtual currency or has the jurisdiction to do so, can do so in the light of these provisions which are applied here. Laws applied section 35A, read with section 36(1)A Banking Regulation Act 1949. Now what does section 35A of the Banking Regulation Act 1949 says? It is the power of the Reserve Bank to give directions. Listen to me very carefully. I am reading the provision 35A. Where the Reserve Bank is satisfied that in the public interest or in the interest of banking policy or to prevent the affairs of any banking company being conducted in a manner detrimental to the interest of the depositors or in a manner prejudicial to the interest of the banking company, or to secure the proper management of any banking company generally. Okay, it is necessary to issue directions to banking companies generally or to any banking company in particular. It may from time to time issue such directions as it deems fit, and the banking companies or the banking company, as the case may be, shall be bound to comply with such directions. Have you understood? That means this is under section 35A of the Banking Regulation Act 1949. The Reserve Bank has the power to give directions to banking companies to involve themselves or not involve themselves in any transaction, but such directions must be issued when the RBI is satisfied that they are necessary to be issued in the interest of public, in the interest of the general public, or in the interest of the banking policy, or to prevent the affairs of any banking company being conducted which is detrimental or which is injurious to the interest of the depositors, or which is prejudicial or which is harmful to the interest of the banking company itself, or to secure the proper management of any banking company generally. So basically the RBI has the authority to issue directions. So 35A of the Banking Regulation Act 1949 clearly establishes the power of the RBI to issue such directions. Okay. Now what is section 36(1)(a) says? Which provision is involved? Section 36(1)(a). The Reserve Bank may caution or prohibit banking companies or any banking company in particular against entering into any particular transaction or class of transactions, and generally give advice to any banking company. So basically section 36(1)(a) gives the power to the Reserve Bank of India to caution or prohibit the banking companies from engaging in any particular transaction or in any class of transactions, and generally give advice to any banking company. So that means according to section 35A and section 36(1)(a) of the Banking Regulation Act 1949, together we can deduce very easily that the RBI has the power to issue such directions and prohibit any company, banking institution from engaging in any particular transaction or class of transactions. Okay, have you understood here? These two provisions are very easy. Now what is the other provision? The other provision is section 56 of the Banking Regulation Act 1949. Now what does section 56 of the Banking Regulation Act 1959 says? Now you tell me, before I begin reading section 56 of the Banking Regulation Act 1949, please tell me, have you understood section 35A and section 36(1)(a)? Please tell me if you have not understood. Okay, Mehul has understood. Taran has also understood. Okay. Now moving ahead on section 56 of the Banking Regulation Act 1949. Act to apply to cooperative societies subject to modifications. The provisions of this act as in force for the time being shall apply to or in relation to cooperative societies as they apply to or in relation to banking companies subject to the following modifications, namely: throughout this act, unless the context otherwise requires, references to a banking company or the company or such company shall be construed as references to a cooperative bank. References to commencement of this act shall be construed as references to commencement of the banking laws application to Cooperative Societies Act 1965. So basically, we have already done a case on this issue that the cooperative societies, they are formed under the Cooperative Societies Act of 1912. Okay, and cooperative banks can, are they registered as cooperative societies? Cooperative banks, any cooperative society which is involved in the banking transactions or banking activities primarily, has to be included within the definition of banks. We cannot simply categorize cooperative banks into the categorize as different from the commercial banks, mainly because they are cooperative banks. If they are from somewhere primarily involved in the banking activities, then 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 the cooperative banks are to be included within the definition of the banking company. So section 56 basically states that the cooperative banks will be included within the definition of banking company, and any reference made to banking company shall be construed as including the cooperative banks also. So if any directives are issued by the RBI for the banking companies, they shall equally apply to the cooperative banks also. This is section 56. Okay. They shall not be kept outside the purview of the banking company. We cannot say that the RBI has issued directions or directives only for commercial banks and we are a cooperative bank and we are not covered by these directives. No, we are also a banking company, irrespective of the nature of our society or the nature of the bank. We are also included within the definition of the banking company. Okay. Now Zinnia is asking, sir, but cryptocurrency has no legal standing as no law is made to regulate it in India. Then why is it RBI's jurisdiction to regulate them? Exactly. Zinnia, you have rightly pointed out, this is what we are going to come out with in the end of the case. Because the Supreme Court has already said this, but perhaps with some other reason. Since we do not have any law, the RBI can issue directives, but we are particularly talking about the cryptocurrencies, whether the RBI has the power to issue these directives or not against cryptocurrencies. Section 35A, Section 36(1)(a, okay, they clearly establish the RBI's power to issue directives. But the question of law that is to be mooted in this case is whether these powers apply on the cryptocurrencies also or not. Section 56 simply extends these powers to cooperative banks also. Okay. Now moving ahead, what is the other provision? Other provision is Section 45JA and 45L of the Reserve Bank of India Act 1934. Okay. Now 45JA of the Reserve Bank of India Act 1934. Power of bank to determine policy and issue direction. See, this is yet another provision which is complementing Section 35A and Section 36(1)(a) of the Banking Regulation Act 1949. Okay. Section 45JA, which I am going to read now, is simply complementing the powers of the RBI under Section 35A and Section 36(1)(a) of the Banking Regulation Act 1949. Now listen to me very carefully. Power of the bank to determine policy and issue directions. If the bank is satisfied that in the public interest or to regulate the financial system of the country to its advantage, or to prevent the affairs of any non-banking financial company being conducted in manner detrimental to the interest of the depositors or in a manner prejudicial to the interest of the non-banking financial company, it is necessary or expedient so to do, it may determine the policy and give directions to all or any of the non-banking financial companies relating to the income recognition, accounting standards, making of proper provision for bad and doubtful debts, capital adequacy based on risk weights for assets and credit conversion factors for off-balance sheet items, and also relating to deployment of funds by a non-banking financial company or a class of non-banking financial companies or non-banking financial companies generally, as the case may be, and as such non-banking financial companies shall be bound to follow the policy so determined and the direction so issued. Okay, so basically this is yet another power of the I should not say another power. This is yet the power, the same power of the RBI, which is dealt in yet another section of another law. Okay, that the bank is satisfied that in the public interest or to regulate the financial system of the country, it to its advantage or to prevent the affairs of any non-banking financial company being conducted in a manner which are against the public order or against the interests of the depositors, which are prejudicial to the interest of non-banking financial company. It has the power to give directions and determine the policy in such circumstance. So this is yet another power of the Reserve Bank of India to determine the policy in such cases and issue directions. Okay? Have you understood section 45JA? Now what is section 45L of the Reserve Bank of India Act 1934? Power of bank to call for information from financial institutions and to give directions. This is yet another power of the Reserve Bank of India to call for information from financial institutions and to give directions. If the bank is satisfied for the purpose of enabling it to regulate the credit system of the country to its advantage, it is necessary so to do. It may require financial institutions, either generally or any group of financial institutions or financial institution in particular, to furnish to the bank in such form, at such intervals and within such time, such statements, information or particulars relating to the business of such financial institutions or institution as may be specified by the bank by general or special order. Okay. Now basically this is yet another power of the bank to call for information from financial institutions and to give directions. The RBI can call for any information from any bank that we want all these information relating to this particular transaction or this class of transactions. Okay, we have the power to give directions. If the bank is satisfied for the purpose of enabling it to regulate the credit system of the country to its advantage, it is necessary so to do. It may require financial institutions, either generally or any group of financial institutions or financial institution in particular, to furnish to the bank in such form, at such intervals and within such time, such statements, information or particulars relating to the business of such financial institutions or institutions as may be specified by the bank by general or special order. Give to such institutions, either generally or to any such institution in particular, directions relating to the conduct of business by them or by it as financial institutions or institutions. Have you understood section 45L? Basically this is, don't go into what is the long text, okay, of the provision. Just see what is the gist of the law. The gist of the law is simply the power of the bank to call for any information from any banking company and to issue directions. So section 35A and section 36(1)(a) of the Banking Regulation Act 1949 and section 56, section 45J, section 45JA, section 45L of the Reserve Bank of India Act 1934 are all corresponding provisions. They all are complementing each other in some way or the other. Okay. Have you understood? Any problem here? Any problem? Now comes, have you understood or not? Okay, so Soma Sundaram has understood. Have you understood the provisions? Okay. Mehul, Gauthaman, everyone has understood. Okay. Now let us read section 10(2) read with section 18 of the Payment and Settlement Systems Act 2007. Okay, section 10 of the Payment and Settlement Systems Act 2007. Power to determine standards. The Reserve Bank may from time to time prescribe the format of payment instructions and the size and shape of such instructions, the timings to be maintained by payment systems, the manner of transfer of funds within the payment system, either through paper, electronic means, or in any other manner between banks or between banks and other system participants, such other standards to be complied with the payment systems generally, the criteria for membership of payment systems including continuation, termination and rejection of membership, the conditions subject to which the system participants shall participate in such fund transfers, and the right and obligations of the system participants in such funds. Okay. So basically the RBI under section 10 of the Payments and Settlements Systems Act 2007 has the power to determine standards. Okay. What kind of format should be there for payment instructions? What should be the size and shape of such instructions? Okay. What are the timings to be maintained by payment systems? Okay, we engage in various electronic transactions today, and therefore every single standard and every single movement is decided and determined by the Reserve Bank of India, and that's what exactly the power of the RBI, which is contained under section 10 of the Payment and Settlement Systems Act 2007. Okay, have you understood? So basically, not going into the nitties and gritties of section 10, the only gist that we have to understand here is that every standards and parameters are determined by the RBI, and this power to determine these standards are contained under section 10 of the Payment and Settlement Systems Act 2007. Okay, that's it. Then if this section 10 has to be read in isolation, but along with section 18 of the Payment and Settlement Systems Act 2007. Section 18 of the Payment and Settlement Systems Act 2007 says the power of Reserve Bank to give directions generally without prejudice to the provisions of the foregoing. The Reserve Bank may, if it is satisfied that for the purpose of enabling it to regulate the payment systems or in the interest of management or operation of any of the payment systems or in the public interest, it is necessary so to do, lay down policies relating to the regulation of payment systems, including electronic, non-electronic, domestic, and international payment systems affecting domestic transactions, and give such directions in writing as it may consider necessary to system providers or the system participants or any other person, either generally or to any such agency, and in particular pertaining to the conduct of business relating to payment systems. Okay, so the RBI has the power to give directions generally with regard to the payment systems if such directions are issued in the interest of management or operation of any payment systems or in the public interest, or it is necessary to lay down such kinds of policies for the regulation of payment systems. How the payments are to be standardized, what parameters are to be set and determined for these payment systems and settlement systems. These are the powers contained under section 10 and section 18 of the Payment and Settlements Systems Act 2007. Ananya, see, we are discussing here, basically I will tell you in one line only. We are discussing whether the Reserve Bank of India has the jurisdiction to prohibit the transactions, to prohibit the banking company from indulging in transactions of virtual currency or not. And so far we have read so many sections and so many provisions under various laws of Banking Regulation Act 1949, Reserve Bank of India Act 1934, and Payment and Settlement Systems Act of 2007. And the gist and in what all we can infer after reading all these provisions of these three laws, that the RBI has the power to issue directions and prohibit the banking companies from indulging in any particular transaction or class of transactions. Here, in this case, the Internet and Mobile Association of India filed a petition against the RBI challenging its directions or directives or circular which it had issued against the prohibiting the banking companies from indulging in any transaction dealing in virtual currency. So the question of law that is to be decided and mooted here is whether the banking company the RBI has the jurisdiction to prohibit the virtual currency transactions or not. We understand there are various sections, like the sections that we have gone through right now, under the Banking Regulation Act, under the Reserve Bank of India Act, under the Payment and Settlement Systems Act 2007, that the RBI has the power to issue directions and prohibit the banking company to do so. But whether these powers apply against the virtual currency also is a question to be decided. Okay, there's no doubt about it that the RBI can issue directions and can bring out a circular. But whether this circular is applicable on virtual currency, which is not yet regulated by any law, that is the question. Okay, contentions made by the petitioner. The petitioner contended, that means the Internet and Mobile Association of India contended that the RBI lacked the authority to prohibit cryptocurrency trading, and that the restriction was also the result of a misunderstanding. It went on to say that cryptocurrency or virtual money is a store of value or medium of exchange rather than a currency, note or coin. The petitioner further argued that virtual currency or cryptocurrencies are a medium of trade or a store of value rather than a monetary note or coin. Okay. What were the petitioners contending? The petitioners were challenging the authenticity and validity of the circular prohibiting the banks from indulging in transactions dealing in virtual currencies. Okay. The petitioner contended that the RBI does not have authority, does not have power to prohibit cryptocurrency trading, and that the restriction was also the result of a misunderstanding. The petitioners were basically contending that even if we buy this argument that under Section 35A, Section 36(1)A of the Banking Regulation Act, under Section 45JA and 45L of the RBI Act, the RBI has the power to issue these directions and prohibit the banking companies from indulging in any particular transaction or class of transactions. But these prohibitions should be based on genuine and concrete reasons. Here, the restriction of the RBI is simply based on a misapprehension, a misunderstanding, an assumption or a myth about the virtual currency which has not yet been busted. There are no proofs that the cryptocurrency leads to money laundering or it funds the terrorist acts. There is no proof of it. This is simply an assumption of the RBI that it is vulnerable to hacking or it is vulnerable to the terrorist acts. So it is a result of a sheer misunderstanding, and based on assumptions, the RBI cannot use its powers simply which are based on assumptions, mere assumptions, misunderstandings or myths. Have you understood the contention of the petitioner? It went on to say that cryptocurrency or virtual money is a store of value or medium of exchange rather than currency, note or coin. It is just a medium of exchange. It's a store of value. People are investing in it and they are trying to make money out of it. So it's not a currency note or a coin which can be dealt by the RBI the way it wants to. Okay. The RBI's power, the powers of the RBI, they are enforceable against the currencies, proper currencies. However, the cryptocurrencies are not the proper currency having content of notes or coins. It's a virtual money. It's a store of value. And so the powers of the RBI are not enforceable against cryptocurrencies. Okay. The petitioner further argued that virtual currency or cryptocurrencies are a medium of trade or a store of value rather than a monetary note or coin. So have you understood the contention of the petitioner? Have you understood the contention of the petitioner or not? Soma Sundarama has understood. And no one else? Okay, so contentions made by the respondents. The respondent disputed with the first argument, like the RBI is the respondent in this case. So the RBI disputed with the first argument, claiming that the RBI lacks jurisdiction and that it is a form of digital payment over which the RBI has control. Okay. In response to the claim that cryptocurrency or virtual currency is a store of value or medium of exchange rather than a type of currency note or coin, the respondent stated that such virtual currency is a stainless digital currency that is used for trading and that cryptocurrency operates independently and without government interference. So what was the contention of the RBI? The RBI said that it is a stainless digital currency that is used for trading and that cryptocurrency operates independently and without government interference. And it is a currency. No matter it is virtual or it is a real currency, it is a currency. So our powers and jurisdictions, they extend to digital payments also, they extend to virtual currency also. Okay, it's not that our jurisdiction only extends to the real currency only the currency having notes or coins. It's a virtual currency, people are trading in it, and since it is a medium of trade, and so the RBI has the jurisdiction to, to cover this. Okay. The RBI has the power to cover this. Have you understood? Have you understood the respondent's contention? It is a medium of exchange. It is a virtual currency. RBI is saying that our jurisdiction extends to any currency irrespective of its nature, whether it's real or virtual, doesn't matter. It's a currency, it's a store of value, it's a mode of digital payment, and so our jurisdiction extends over it. That's it. And it's a simple, straight-jacketed formula that our jurisdiction extends to any form of currency. We are calling it a virtual currency. We are calling it a cryptocurrency. And since it is categorized as a currency, our jurisdiction extends to it. That's it. Understood? Understood or not? Before we read the decision of the court, please tell me if you have understood both the contentions and also the provisions we have read. Okay, so Nakshi, Riaz, Somasundaram, Taran, Rakhi, Mehul all have understood the contentions. Gauthaman has also understood. Okay, so the decision of the court. In this case, the Honorable Supreme Court found that while the Reserve Bank of India has broad powers and plays an important role in the development of the Indian economy, it is unable to establish any harm to its regulated firms. As a result, the Reserve Bank of India's directives urging banks to stop engaging with or providing services to commodities traders using virtual currency are illegal and so unenforceable. Okay. In this case, the Honorable Supreme Court found that while the RBI has broad powers and plays an important role in the development of the Indian economy, it is unable to establish any harm to its regulated firms. As a result, the Reserve Bank of India's directives urging banks to stop engaging with or providing services to commodities traders using virtual currency are illegal and so unenforceable. Have you understood the decision? Understood what this paragraph says? The directives issued by the RBI that was through a circular which was challenged by Internet and Mobile Association was held to be illegal and unenforceable. Do you know why? Because the Supreme Court accepted the arguments of the petitioner that the assumptions, these are mere assumptions, these are mere suspicions, these are mere sheer misunderstandings and myths which the RBI has itself created without any concrete reasons, and these assumptions are not corroborated by any vulnerability which has been substantively proved. So therefore, we are unable to establish and find out any harm to its regulated firms. The banks are involved in it, people are investing in it. There's no substantive proof to corroborate any vulnerability of such transactions, and therefore, since it is difficult, we are finding it difficult and unable to establish any harm to its regulated firms. So the directives of the RBI urging banks to stop engaging with or providing services to commodities traders using virtual currency, they are all illegal and unenforceable. They are all unenforceable. Why? Because these are all mere assumptions and we are not able to find or establish any harm to its regulated firms. Okay? Understood? Understood? Any question? You're most welcome to put up questions now. Abhimanyu says no question, sir. Understood. Okay then. Fine. Taran, bearing in mind that they are merely a store of value which is meant for trading, shouldn't they be regulated by SEBI? Yes, perhaps, Taran, I can say yes, but what difference will it make? It should be regulated by some institution, I guess. Now it has fallen even outside the jurisdiction of the RBI. It should be regulated by Securities and Exchange Board of India also. But you know, at the international, there is no regulation even at the international level. Either there are two options: to create an international regulation mechanism for the cryptocurrencies, or to create domestic regulation policies. The countries should create their own domestic mechanisms for the regulation of cryptocurrencies. And if that happens, if the latter happens, then the India can go for authorizing the Securities and Exchange Board of India in for regulating the cryptocurrencies in India at least, right? But if I say yes to your answer, what difference will it make? Because right now it's completely something virtual, something which is like virtual is enough word to and make you understand that there is hardly a reality hidden in these currencies, right? Anything else? Okay, then I'm signing off, and hope to see you tomorrow with another judgment. Okay. Till then, all the very best, and bye bye. Thank you.